In other stories, concluding a 12-day visit to Sri Lanka, the United Nations Working Group on Arbitrary Detention states that Sri Lanka should immediately implement reforms to end arbitrary detention. They also raised concerns over excessive and unjustified delays of court proceedings, adding that the right to the presumption of innocence and the due process have not been fully recognized. They made these remarks at a media briefing held in Colombo today.
During the visit, we have recognised a number of positive initiatives on the part of the Government of Sri Lanka, including its engagement with UN human rights mechanisms, as well as the recent accession to the optional protocol to the Convention Against Torture. However, more action is required to give effect to Sri Lanka's obligations under international human rights law, as well as to the commitments made by the government under its Human Rights National Action Plan 2017 to 2021. In particular, we found that the right to personal liberty has yet to be respected by law enforcement, security forces, judicial and other authorities. In particular, we found that there's an urgent need for reform to address problems including the excessive use of remand and pre-trial detention, a lack of effective alternatives to detention, an outdated legal framework and reliance on confessions often extracted under torture, duress or coercion. Court proceedings are affected by excessive and unjustified delays, while suspects remain in detention indefinitely. The presumption of innocence and due process are yet to be fully recognised across Sri Lanka. We also learned about the special laws and powers enacted during the state of emergency, and in particular the working group urges the Government of Sri Lanka to repeal the Prevention of Terrorism Act 1979 as one of the key enablers of arbitrary detention for over 4 decades in this country. We also found that detainees in general do not enjoy some of the most fundamental guarantees of due process, such as immediate access to legal assistance from the moment of arrest and before an initial statement is made by suspects. We find this to be of great concern and is particularly occurring at police stations. During our visit, we also concentrated on other situations of deprivation of liberty, particularly people in situations of vulnerability, such as women, children, elderly people, people living with psychosocial disabilities and those living in poverty. Despite identifying positive practices in this regard, we are concerned that a clear legal basis and procedures for depriving people of their liberty have not yet been clearly established. We also found that there are no effective safeguards against arbitrariness in this context, and that there's an urgent need to strengthen mechanisms for independent monitoring and oversight.
With regards to the National Police Commission, we met with them and we received information on the complaints that they received. What we found out is that those mechanisms to address complaints by police abuse should be strengthened. They seem to have the necessity to have clearer procedures in which persons that present the complaints are informed and that the results might lead to successful punishment to those who claim to be abused. We indeed visited the military base. We had free access to all places within the compound. With regard to the National Human Rights Commission report, we are aware of the report. We are aware that they have complaints on arbitrary detention abuses, but we did not receive the detailed information about what's in those 209 complaints. It's not within our mandate to deal with individual cases through country visits. We can receive through our regular procedure complaints about arbitrary detention.
To add to the question on the Joseph camp, you said that you got free access within the military premises. What was the impression about the place, and did you see any signs to suggest that the premises has been used as a detention center for itself?
We visited the premises and we received information that that place has not been used for detention of civilians for a long time. We visited 3 cells, but we were informed that those cells are used for military temporary detentions so that they can address issues related to disciplinary measures. We did not see anything out of order in the premises and the buildings that we visited.
We heard many stories of people who had been detained in pre-trial detention for extensive periods of time. We heard people that had not had access to lawyers during that pre-trial detention and in fact during the trial and appeal period. We heard stories of people who had been coerced to make statements at different periods of time as well.
What we heard from persons deprived of liberty were not exclusively and necessarily negative things about the system, but we heard, of course, negative things about the system. We heard various things that are of our concern. There is a challenge in the country to have a systematic legal representation for all persons that are deprived of liberty. One of the main findings that you will see in our preliminary findings is that from the prisons that we visited, most of them are overcrowded. So that there is an issue of concern for the working group, the overcrowding of prison facilities.